All right, I'm going to answer the question, how to protect a new software app idea. I am JD Houvener, a patent attorney and founder at Bold Patents Law Firm, also the author of Bold Ideas, The Inventor's Guide to Patents. I've spent over 10 years helping thousands of inventors and helping them get almost 500 patents as of today. So I'm happy to share my knowledge in this area of the law and walk you through some of this really important information about a new app idea. Apps, right? Software apps, cell phone, mobile apps, those have been around for the past 10, 15 years. And it's kind of, one of those concepts that I love talking about because it's inspiring to those creators that have developed the acumen to learn about coding, learn about Python, whatever the latest, language that some of these apps are used, to get them out to the masses immediately. And it allows some of them to be able to get that huge market potential and see if they can make a big splash, right? See if they can go viral and get picked up by people that want to get better, be more efficient, or just have more fun. As we've seen over the years, many apps come and go. And the idea of an app or a software application is important to understand in the context of patent law, because there are sometimes areas where software doesn't make sense to get a patent on it. And there's two major areas. We'll cover the first one, which is an important one, about abstract ideas, or ideas that are merely part of human nature, okay? So you are not allowed to file, it's not eligible to file an abstract idea and try to get a patent on it. It kind of makes sense, right? You're not going to be able to explain it well enough so that someone in the field would be able to understand it, make it, and use it. That's one of the major reasons why the US government gives a 20-year monopoly to an inventor as a reward, because they're now saying, thank you. You've all helped us make it smarter, and understand the concept, the invention you've come up with, so that at the end of that 20 years, we all can practice it, right? We all get to have a chance at doing what you've explained, what you've come up with. And so if you're not able to articulate it, if you can't explain it in enough detail, it's too abstract, meaning it doesn't have tangible, right? You can't actually explain how it works, or it's merely human nature. In other words, what you're trying to claim is already being done in the world around us, and you're just sort of putting that into the internet or into some autonomous machine that's really just doing that, and it mirrors it so closely to what happens in real life or in human situations that there's really no ingenuity, there's no human spark, there's nothing added, right? There's abstract. That's what the courts have said. It's a little tricky to understand. I'm happy to walk through that analysis if you think you might be towing the line on that. The second big issue with software is sometimes it's so detailed, right, that what you would want to protect is a series of processes, right? Your source code, 6 steps to analyze, to move, to translate the data, maybe compress it, right? Video compression, or maybe you're doing something with, the actual data itself, and you're refining it, and you're validating it, or you're maybe moving that data into something else and converting it. Whatever those steps are, right? Insert the verb, the technical verb. That is change, right? That is ingenuity, and the combination of those steps is what you're hoping is unique, and you want to seek a patent on it. The question is, if that process were followed to the T exactly by your competitor, even if you had a patent on it, would you be able to tell that they're infringing? And so detectability on software is really challenging without having the ability to be in-house or see or have discovery. And so if it's really going to be hard after looking at it and thinking about what the general public would see, what you would see if you bought a competitor's product, would you be able to tell that they're ripping you off? Would you be able to tell that they're copying your software, your app? And the answer is yes, thumbs up. That looks like maybe you've got a more enforceable, identifiable patent where you'd be able to see, yep, someone else is infringing. It's clear. Here's how we would do it. That's lean toward getting a patent. If it's going to be really hard or almost impossible to be able to tell how they did it, you might want to keep that as a trade secret. And there are ways to govern that with your employment documents, making sure there's really a high level of confidentiality. Not all employees would have access to that source code, right? That series of 6 or 7 steps. And it would be under in your employment agreement that they're not allowed to share or take that information to their own company or the competitor company when they leave. So it's a different area of law, and you do take the risks that that information becomes well known in the public, and no longer you don't longer have trade secret ability. And second, maybe a competitor decides to file a patent on that trade secret information. Well, certainly now it's part of the public, and now they've been able to help maybe secure patent protection in that area. So different ways to navigate this, and it's a great idea to go have a conversation with a patent attorney to learn about which option is best, where do you sit, and if you're somewhere in the middle, it's a good opportunity to learn what the best situation is for you to move forward. All right, well, hope this was educational for you, and maybe you have a new software app, you want to learn more about how to get started. Click below, we have our free Inventors kit below. That'll get you started with my book, the PDF, new search options, as well as applications that you can draft and protect yourself. I'm JD Houvener, owner and founder here at Bold Patents Law Firm, wishing you a wonderful day. Go big, go bold.